So today's webinar will be a discussion of some of the most common topics that we see in requests for technical assistance. We plan to discuss these with a mix of lecture, hypotheticals, and poll questions. And after attending today's webinar, attendees will be better able to, number one, assess whether an immigrant survivor is inadmissible for a crime involving moral turpitude or a CIMT, to develop appropriate strategies for responding to late-breaking inadmissibility in survivor-based cases, to develop appropriate strategies for vaccine-related issues in survivor-based cases, to understand the new unlawful presence rules and their application to survivor-based cases, to develop arguments that the VAWA-based waiver of the permanent bar should apply in cases of abuse by the non-qualifying abuser, and finally, to develop some appropriate strategies for troubleshooting issues with USCIS that come up in your cases. Next slide, please. So we're going to start off with a lesson on the CIMT ground of inadmissibility, and then we're going to walk through how those rules are actually applied in practice with a hypothetical. We're then going to discuss late-breaking inadmissibility and some hypotheticals on that topic. We'll then transition to a discussion of vaccine-related issues with a hypothetical, as well as an overview of the health-related grounds of inadmissibility. We'll talk about the unlawful presence rules and then teach that with a hypothetical. We'll talk about the VAWA-based waiver of the permanent bar, the differences between the statute and how USCIS interprets it. And then we'll do a hypothetical and come up with some arguments that we can make for why abuse by the non-qualifying abuser should qualify a survivor for that waiver. We'll then talk about some best practices for troubleshooting USCIS issues, and then we've set aside some time at the end of the webinar for Q&A. Next slide, please. So CIMTs, they're important to consider in your survivor-based cases because I'm sure you know many immigrant survivors are criminalized. And given this intersection of survivorship and criminalization, we are excited to expand our offerings in the area of the intersection between crimes and survivor-based immigration relief. That said, we do want to emphasize that we are not the experts on criminal grounds of inadmissibility. You should still feel free to reach out to us for technical assistance if you have questions about how a criminal conviction impacts your survivor client, but please also feel free to consult the resources in your materials that are written by the real expert organizations like the Immigrant Defense Project, the Immigrant Legal Resource Center, and the National Immigration Project of the National Lawyers Guild. Some of these organizations do offer technical assistance as well, and we encourage you all to consider them if you have questions on the intersection of immigration and crimes. I plan on teaching this topic by discussing the law around CIMTs and then moving to a hypothetical client scenario so you can see how those laws are actually applied in practice. Please feel free to put any questions that you have in the Q&A box while I am talking. I've set aside a few minutes between the lecture portion and the hypothetical portion to answer any questions that come up. But if I'm not able to answer your question during that time, we have set aside some time at the end of the webinar as well to address your questions. Next slide, please. So why do CIMTs matter? Because they're a ground of inadmissibility. They're a conditional bar to good moral character if the CIMT was committed during the statutory period, which, for example, for VAWA self-petitions is 3 years by regulation, and they may be a ground of deportability in some cases. Admissibility, of course, is a consideration for U and T non-immigrant status, for VAWA adjustment of status, and T adjustment of status. Good moral character is a consideration for VAWA self-petitions, VAWA cancellation of removal, and T adjustment of status. And grounds of deportability, which are found at INA 237, apply to survivors who have been granted LPR status, including through UT and VAWA-based relief, but who have not yet become naturalized citizens. So these are all of the contexts where CIMTs can come up and potentially present issues in your survivor-based cases. Next slide, please. So what is a CIMT? It's a crime that contains two essential elements: reprehensible conduct and a culpable mental state. To be a CIMT, that culpable mental state, it has to rise to a certain level. It has to be, at the very least, a conscious disregard of a substantial and unjustifiable risk. So that means that criminal negligence that simply requires a lack of awareness of a substantial risk is not sufficient for that crime to be a CIMT. You'll see the case matter of Tavdidishvili on your slide. That was a case on New York negligent homicide, where obviously very grave harm resulted from that crime. But the BIA held that this crime was still not a CIMT because the culpable mental state was lacking in that case. And that case really shows that you do have to focus on whether that culpable mental state is there before conceding that a crime is a CIMT. And the gravity of the harm caused is not going to be enough to say that that crime is a CIMT. So you need the culpable mental state. You also need the reprehensible conduct. And that is defined as conduct that is inherently base, vile, or depraved, and contrary to the accepted rules of morality and the duties owed between persons and to society, or to society in general. Now, obviously, that definition is very vague. So for CIMT analysis, we often look to the different categories of CIMTs, which we find from BIA and circuit case law. And we're going to talk about some of those categories on the next slide. Next slide, please. So this chart is a helpful starting point on the types of crimes that are either often considered or not considered CIMTs. But you should always check your circuit law, because a lot of this is very circuit specific, and this chart is not meant to be comprehensive. I'd also like to note that some state statutes in the categories of crime that the BIA has said are CIMTs might still be broader or punish more conduct than the CIMT definition, meaning that those crimes are actually not CIMTs. And as examples, in Hawaii and Maryland, the circuit courts have found that theft in those jurisdictions is not considered a CIMT, even though the BIA's definition of theft as a CIMT has gotten a lot broader since 2016. You'll see here that aggravated DUI is considered a CIMT. Do keep in mind, though, that just because the crime is called aggravated DUI, that doesn't mean that it will be a CIMT. You have to look at the culpable mental state and the language of the specific statute that your client was convicted under. An Arizona aggravated DUI statute in matter of Lopez Meza, which is a BIA case in your materials, required that the person who got the DUI not only had a DUI, but that they had knowledge that their driver's license was suspended or revoked. And that knowledge is the reason why that crime was a CIMT, not the fact that the statute was titled aggravated DUI. On the other hand, so-called simple DUI, that's not a CIMT because there's no culpable mental state often in those cases. And remember that you do need both that reprehensible conduct and the mental state that is sufficiently culpable. You'll see here that there's an asterisk next to possession with intent to sell drugs as a CIMT. Often that is the case, but there may be an argument in the Ninth Circuit that possession with intent to sell less than 2 pounds of marijuana is not a CIMT. There's a case in your materials called Walcott versus Garland from the Ninth Circuit that's about an Arizona statute. And that case has some really great reasoning that incorporates the evolving societal views on marijuana in its explanation of why this is not a CIMT. So it shows that the definition of what is considered reprehensible conduct can change with the times, and that an important factor is the fact that, our society is moving towards a more permissive view of marijuana offenses. So especially those of you who are in the Ninth Circuit, I would encourage you to take a look at that case. But even those of you who aren't, it has some really great arguments that you can make in your cases. You can also see from your slide that drug possession is not a CIMT. And that is because possession offenses often don't contain that culpable mental state. Often they actually have no mental state, let alone a conscious disregard of a substantial and unjustifiable risk. That said, though, keep in mind that a simple possession offense, it could still be considered a controlled substance offense, which is a different and separate ground of inadmissibility that doesn't require any culpable mental state at all. On the flip side, possession with intent to sell drugs could be both a CIMT and a controlled substance offense. So just keep in mind that while controlled substance offenses are a whole separate webinar topic that are outside the scope of today's webinar, some crimes should be analyzed under multiple grounds of inadmissibility and could potentially raise more than one criminal inadmissibility concern. Next slide, please. So how do you know whether a crime is a CIMT? To determine this, you use what is called the categorical and the modified categorical approach. And which approach you use depends on whether the statute is indivisible or divisible, which is a distinction that we're going to talk about later in the webinar. Under both of these approaches, what you're doing is you're comparing the minimum conduct of the statute of conviction to the generic definition of a CIMT. For example, you would be comparing your client's drug distribution conviction to the BIA and circuit case law on drug distribution as a CIMT. And if your client's statute of conviction punishes more conduct than the generic definition, then your client's statute of conviction is considered overbroad. In both the categorical and modified categorical approaches, what the client actually did is irrelevant because we're only focusing on the minimum prosecutable conduct as opposed to the client's actual conduct. And the adjudicator has to assume under both of these approaches that the client only committed the minimum conduct that could potentially be punished by the statute. There is not a consideration of what the client actually did. And when you're looking for what is the generic definition of a CIMT that I should be comparing my client's case to, you're looking at primarily BIA decisions and circuit case law. Next slide, please. So we're talking about, with a CIMT, you have to see whether there is the client's statute of conviction, if the minimum conduct is broader or the same or less than the generic definition. So how do you find that minimum conduct? That approach, it depends on which circuit you're in. There's two primary approaches. The first is called the express language rule, which is followed by the majority of circuits, as you can see here on your slide. The other is called the actual case requirement, and that is followed in the Fifth and the Sixth Circuits. The BIA also uses the actual case requirement, but they should be following circuit law if your circuit uses the express language rule. The case law is somewhat ambiguous in the Fourth and the Seventh Circuits. Some cases suggest an express language rule, and others suggest an actual case requirement. There are cases from these circuits in your materials. If you're in one of those circuits, we encourage you to take a look at those cases and to draw your own conclusions. You also might want to review the practice advisory that's in your materials on what's called the realistic probability test from the National Immigration Project and the Immigrant Defense Project. To give an example of how the express language rule works, let's say your client's statute says that assault can be accomplished by offensive touching. If you're in an express language jurisdiction, the minimum conduct for assault in that state is offensive touching, because that's what the statute says. On the other hand, if you are in an actual case jurisdiction, it's unfortunately not enough that the statute itself says that assault can be accomplished by offensive touching. You would have to, in order to argue that the statute is overbroad and that your client's conviction under that statute is not a CIMT, you'd have to find an actual case where someone was convicted under that statute for offensive touching. If you're in an actual case circuit, you can run a search of the statute to find cases where a person was convicted for non-generic conduct, and then use the existence of that case to show that the statute your client was convicted of is overbroad and that the client does not have a CIMT conviction. When you're doing this type of research, to the extent it's possible, try to find cases where a person was convicted for conduct that is perhaps unwise, but is not inherently base, vile, or depraved. You can find some very absurd examples if you take the time to do the research. Texas disorderly conduct is one. Convictions have been upheld under that statute for a person who gave the finger to their principal at high school graduation, and to someone who cursed at authority figures. Now, perhaps we could maybe agree that that behavior is unwise, but it's much less reprehensible than some of the other behavior that's involved in crimes that have been considered CIMTs, like aggravated assault. So that would be an example of the type of argument you would make to say that that is not a CIMT, because here are real world examples where people have been convicted under this law for conduct that is not inherently base, vile, or depraved. The realistic probability advisory that's in your materials, which I talked about before, that has some really great arguments for why we shouldn't even have to do this in the Fifth and Sixth Circuits, why we shouldn't have to find actual cases of convictions for non-generic conduct. But for now, we are stuck with it in those circuits unless some changes come about through litigation. Next slide, please. So what about divisibility? I talked about that before. That determines whether you're using the categorical or the modified categorical approach to find the minimum conduct that's punished by your client's statute of conviction. Often divisibility comes up when a statute lists alternatives. And to figure out whether a statute that has alternatives is divisible, you have to figure out whether those alternatives are elements or means. And elements are what a jury has to find unanimously in order to convict somebody. And means do not require the jury to be unanimous. And if the jury does not have to be unanimous on something, it is not an element. So keep that in mind. For a statute to be indivisible, it has to have one set of elements. And if a statute has a list of alternatives that are just means, meaning that the jury does not have to be unanimous on them, those alternatives are not elements, and that statute remains indivisible despite the fact that it has alternatives in it. The statute does have to contain the word or in order to be divisible, but as we'll see in the next slide, the use of the term or alone is not enough to make a statute divisible. The jury does have to be unanimous on those different statutory alternatives in order to say that that statute is truly divisible. Next slide, please. So when you're trying to figure out whether or not a statute is divisible, a good place to start is the state case law that interprets the statute. Sometimes that case law will answer the question of whether a statutory alternative is truly an element that the jury has to be unanimous on. Another good place to look is at the jury instructions for your client's statute of conviction. Sometimes those instructions will tell you what the jury has to be unanimous on. If the jury does not have to be unanimous on the ways in which the defendant committed the crime, such as through, for example, bodily injury or offensive touching, those ways of committing the crime, bodily injury or offensive touching, they're simply means, and that statute remains indivisible, even though there are alternatives in it. If you still can't find the answer by looking at case law and jury instructions, you can also review the documents that are in your client's record of conviction. So let's say that your client pleaded guilty to Statute 101, which has two subsections, bodily injury and offensive touching. And let's assume that your client's plea agreement says that they pleaded guilty to bodily contact without specifying any particular type of bodily contact. Mathis versus United States, which is an important Supreme Court case on the categorical approach, which is in your materials, suggested that an umbrella term in a record of conviction, like bodily contact, that the presence of a term like that means that the statute is indivisible. Since the conviction record documents might be determinative in these cases, it makes sense to try to get transcripts, if you can, of the client's plea hearing to see what they were required to admit in court when they pleaded guilty, and to always be carefully reviewing your client's plea agreements to see if they contain the type of umbrella terms that would suggest that the statute is indivisible. Now let's look at the example on your slide, which is adapted from Mathis. Under this statute, the defendant must unlawfully enter a place to commit burglary. That place might be a home, a car, or a boat. So we see that the statute has alternatives, and it has that word "or" in there. It's clear that the jury has to unanimously agree, or does not have to unanimously agree, I'm sorry, on which place the defendant entered. The fact that the defendant entered a place is an element, but you'll see that which place the defendant entered is not an element, because the jury does not have to be unanimous on which of those places the defendant entered. And remember that if the jury does not have to agree on an alternative, here, home, car, or boat, it's not an element. So this statute would be indivisible. Next slide, please. So we just had the burglary example. What if we change the facts? What if the jury did have to agree on whether the defendant entered a home, a car, or a boat? Would that statute, given that the jury has to agree, be divisible or indivisible? Give folks 30 seconds to respond. Okay, we'll go ahead and close the poll. So we have 61% divisible and 39% indivisible. So the statute would be divisible here because the jury is required to agree on which specific place the defendant entered. So now the specific place, either home, car, or boat, those are now elements of that statute instead of just means. Burglary by entering a car, burglary by entering a home, and burglary by entering a boat are now all completely separate crimes under this statute. And if you had a survivor client who was convicted under that statute, you'd have to figure out which were they convicted of. Were they convicted of burglarizing a home, burglarizing a home, a car, or a boat, in order to figure out what the minimum conduct is that you have to compare to the generic conduct, which for burglary is frequently burglary of a home that is at least intermittently occupied. Next slide, please. So again, divisibility matters because it determines whether you're going to use either the categorical or the modified categorical approach. Under the modified categorical approach, you're looking at your client's record of conviction to determine under which subsection of the statute your client was convicted of. So in that burglary example, you'd be looking to see at the client's, for example, plea agreement to see were they convicted of burglarizing a home, a car, or a boat, and they'd be comparing that to the generic conduct. A police report is not part of the record of conviction, so keep that in mind. USCIS can't be using the police report to figure out what the client was convicted of. Even under this approach, where we are looking at the client's record of conviction, we still don't care what the client actually did for the admissibility analysis. So even say your client was convicted of burglarizing a boat, but they actually burglarized a home, that's irrelevant to the admissibility analysis. You're only comparing burglarizing a boat to the generic definition, regardless of what the client actually did. And this approach, where USCIS looks at the client's record of conviction to see what they pleaded guilty to, USCIS can only use that approach if the statute is divisible. If the statute is not divisible, USCIS cannot look at the client's record of conviction and then compare that convicted conduct to the generic definition. Next slide, please. So, okay, I see some questions in the chat. We have, what about the Fourth Circuit for the categorical approach? So the categorical approach does have to be used in all circuits. The question is whether you look at the statutory language to figure out what is the minimum conduct you're comparing to the generic definition. Or are you looking, do you have to find an actual case where someone was convicted of conduct that was broader than that generic definition? The Fourth Circuit, the case law is just a little ambiguous in my personal opinion, but others could differ on that. So I encourage you all to take a look at, there's a couple Fourth Circuit cases in your materials. The more recent case from the Fourth Circuit, I think, is promising in terms of they seem to be moving away from, an actual case requirement. It was a case from 2020 about a Virginia firearms statute, I believe. So I would take a look at that case because that has some really helpful arguments in it, but they never, from what I remember, never explicitly overruled, the earlier case that suggested it was an actual case inquiry. So I think there might still be a little bit of debate there, but definitely take a look at the cases in the materials. I have, what circuit case law would USCIS apply if the client is detained in another circuit than where they reside and their original proceedings were held? My understanding is that they're going to be looking at where the client resides, I believe, at the time that the decision is made in the so if it's a U visa, if the client is detained in, say, the Fifth Circuit at the time of the U visa decision, I could see them applying Fifth Circuit law. But if the client is no longer detained at the time the U visa is adjudicated, I would argue that they should be applying the circuit law where the client is residing. We have a question in the chat. What about convictions abroad? That is a very good question. I'm not 100% positive. My instinct would be that you should follow the circuit law where the client lives. So if the client lives in, say, the Second Circuit, that you should be using the express language rule to compare the generic to compare the minimum conduct of the client's statute of conviction to the generic conduct. That said, it would obviously be harder to research the foreign conviction potentially to see what the statutory language says there. I know that the Library of Congress has some good materials on foreign law research, but if you have like a more case-specific question, definitely feel free to reach out to us for technical assistance, and we would probably have a better answer than the one I just gave now. Are there any additional questions? Okay, so we will move on to the next slide. Next slide, please. So now we're going to work with a hypothetical case to see how these CIMT rules are applied in real life. Next slide, please. So we have Ariel. Ariel's partner, Alejandro, has abused them for years. After Alejandro began strangling Ariel, Ariel slapped Alejandro in the face. The strangulation marks were not visible on Ariel's dark skin, but the slap left a red welt that was immediately visible on Alejandro's light-skinned face. Ariel was unable to communicate with the English-speaking police officer and was arrested. Ariel pleaded guilty to misdemeanor assault in exchange for immediate release from the county jail, where mistreatment of non-binary people is rampant. In Ariel's jurisdiction, conviction for misdemeanor assault can be accomplished by intentional offensive touching or intentional infliction of bodily injury. So we see already that this statute has alternatives. You are representing Ariel on a U visa, and you're assessing their grounds of inadmissibility. And for some background, offensive touching against an intimate partner is not a CIMT, but infliction of bodily injury on an intimate partner is a CIMT. So the generic definition that we're going to compare the minimum conduct to is the infliction of bodily injury on an intimate partner. So just try to keep that in mind as we're working through the hypothetical. Next slide, please. So what is your first step when you're assessing Ariel's grounds of inadmissibility? Would you concede the CIMT ground, seek a waiver, and focus on the connection between the conviction and the abuse? Would you review Ariel's plea agreement to see what they admitted to? Or would you research Ariel's statute of conviction? Give folks about 30 seconds to answer. Okay, and we'll go ahead and close the poll. Okay, thanks. So we are pretty split here. We have 53% who would research the statute. We have 39% who would look at the plea agreement, and we have 9% who would concede the CIMT ground. So let's talk about this. It makes the most sense to, at this very early stage of the case, to research Ariel's statute of conviction. And the reason for that is that reviewing the plea agreement is usually premature until you know whether or not the statute is divisible. The only reason that you'd be reviewing the plea agreement at that really early stage is if you've already looked at the case law and the jury instructions and they haven't answered that question of whether this assault statute is divisible. If you did have to review the plea agreement at this early stage and it just showed Ariel admitting to bodily contact with no admission to either offensive touching or infliction of bodily injury, that type of umbrella term could be evidence that the statute is indivisible. Remember, though, that USCIS, in the inadmissibility analysis, they cannot look at Ariel's plea agreement to see what they admitted to unless the statute is divisible, or if state law is unclear on the question of divisibility, and USCIS is doing it for the sole reason of seeing whether there's an umbrella term in there like bodily contact. The reason to not concede the CIMT ground, at least at this early stage before doing the research, is while there is a waiver available for U visas, T visas, T adjustment in some cases, and VAWA adjustment, the fact that there's a CIMT ground of inadmissibility could impact the discretionary analysis, because, you know, the more grounds of inadmissibility there are, potentially the harsher USCIS will be on that client. There's an AAO case in your materials where USCIS got it wrong on whether the client had a CIMT. That client was still inadmissible for other reasons, but the AAO still remanded the case back to USCIS, and they like explicitly said that whether the client was inadmissible for CIMT affected the discretionary analysis. So USCIS had to redo that analysis. So that's why it's important not to concede the ground before doing the research and making sure that it really does apply. Next slide, please. So you decide to research Ariel's statute of conviction. And when you're researching, what should you focus on? Should you focus on whether you're in an express language or actual case jurisdiction? Should you focus on jury unanimity, or should you focus on both of those things? Okay, we'll go ahead and close the poll. So it looks like vast majority of you said both at 71%. We have 22% wanting to focus on express language versus actual case. And then we have 7% focusing on jury unanimity. It does make sense to research both of those things. The reason for that is because knowing whether the statute is divisible, which requires you to figure out, does the jury have to be unanimous on offensive touching versus bodily injury, helps you figure out what is the minimum conduct that you have to compare against the generic definition. But that doesn't answer all of your questions, because you have to know also, where are you looking for the minimum conduct? Are you looking to the statutory language, or are you looking to, do you have to find an actual case where someone was convicted under this statute for offensive touching? Next slide, please. So you've done your research. You found that unfortunately, Ariel is in an actual case jurisdiction. But helpfully, you also found that the jury does not have to be unanimous on whether there is offensive touching or bodily injury. And remember that the offensive touching against an intimate partner is not a CIMT. There has to be bodily injury. And you found a reported case where a person was convicted under this assault statute for repeatedly tapping another person on the shoulder. So what do you think? Is there a CIMT? Is there not a CIMT? Or are you not sure? Give folks 30 seconds to respond. Do we go ahead and launch the poll? Okay, so for this particular one, just in the interest of time, the statute, oh, I see. Okay, folks did it. Okay, so yeah, the vast majority have said no CIMT. So that is the correct answer. And why is that? The statute is indivisible, meaning there's just one set of elements. Offensive touching and bodily injury are not elements, because the jury does not have to be unanimous on them. And you found an actual case where someone was convicted for what could be termed offensive touching, repeatedly, tapping someone on the shoulder. And we know that that type of conduct is broader than the generic definition of a CIMT, which is the infliction of bodily injury. I have here in the in the description of the poll that you found a reported case. I say that because that is the safest approach to find an actual, reported case of a conviction of non-generic conduct instead of, just like anecdotal examples. And unfortunately, at least in the Fifth Circuit, you are actually required to find a reported case. So that is the safest approach if you're in one of those express language jurisdictions. Next slide, please. So we know that this statute is indisputably indivisible because we found a reported case where someone was convicted for non-generic conduct. And given that, can USCIS look at Ariel's plea agreement to see what they admitted to, given that we know that the statute is indivisible? So give folks about 15 seconds to respond to this. Okay, we'll go ahead and close the poll. So we have 68% say no and 32% say yes. The noes have it. USCIS cannot review Ariel's plea agreement to see what they admitted to. The reason for that is because we already have proof that this statute is indivisible. So there's no need, and in fact, USCIS can't do what's called, some people call it the Mathis peek at the record of conviction. USCIS can't do the peek here because we already know that the statute is indivisible. The only reason they would be able to look at Ariel's plea agreement is if for some reason state law was ambiguous on whether the statute is divisible. In that very small case, USCIS could look at Ariel's plea agreement to see if they admitted to an umbrella term, for example, like bodily contact. But they can't do that here because we already have the answer from state law. And USCIS can never look at Ariel's plea agreement to find what is the minimum conduct that we're comparing against the generic definition because the statute is indivisible. So USCIS, the minimum conduct is that shoulder tapping, regardless of what Ariel may or may not have admitted to in their plea agreement. Next slide, please. Let's change the facts. So you did your research and you found that actually the statute is divisible. Offensive touching and bodily injury are actually elements because the jury has to be unanimous on which one of them was implicated. So what is your next step? Do you concede the CIMT ground because you know that Ariel caused bodily injury against their intimate partner? Or do you look at Ariel's plea agreement to see what they admitted to? Okay, we'll go ahead and close the poll. Okay, so we have an overwhelming majority say to review the plea agreement, 98%. And that is correct. And the reason for that is, remember that even under this modified categorical approach, where now USCIS can look at the plea agreement, we still don't actually care what the client did, at least for purposes of admissibility. We only care about what the judge or jury convicted of the client of, or what the client necessarily had to admit to in court when they pled guilty. And that's why we have to review Ariel's plea agreement before we concede that there's a CIMT, because there's a possibility here that there is not a CIMT. Next slide, please. So say you looked at Ariel's plea agreement and it shows that what they admitted to in court before the judge was offensive touching. And remember that the minimum conduct for offensive touching is repeatedly tapping another person on the shoulder. So it's less than commission of bodily injury. So what would you do? Would you concede the CIMT ground because what actually happened is the commission of bodily injury? Would you submit relevant documents and argue that the conviction is not a CIMT? Or would you refuse to concede the CIMT ground and wait for an RFE before you submit any evidence to USCIS? Give folks about 30 seconds to respond. Okay, we can go ahead and close the poll. So we have 67% saying submit the relevant documents, argue not a CIMT, 23% refuse to concede, and wait for an RFE, and 9% would concede. So remember that it's not a CIMT because we only care about the minimum conduct that could be punished. And we found already that the minimum conduct that could be punished is that shoulder tapping. So that's what we're comparing to the bodily injury, not what Ariel actually did. So you wouldn't want to concede the ground of inadmissibility here, because under the approach that USCIS has to use in these cases, Ariel has not committed, is not inadmissible for a CIMT. With number 2 versus number 3, it is a bit of a judgment call, and practitioners might have good faith differences of opinion on this. That said, remember that in an application for relief, it is the non-citizen's burden to show that they're not inadmissible, so they have to prove a negative. And part of meeting that burden is submitting evidence and argument about why a conviction is not does not render that client inadmissible. Plus, addressing these issues from the start gives Ariel a chance to control the narrative rather than letting USCIS imagine the worst about them. What documents would you submit here? It makes sense to include the reported case that you found of a conviction for non-generic conduct. You should at least provide the Blue Book citation to that case in your cover letter. But to make sure that USCIS notices the case, you might actually want to print it out and attach it to your submission. You'll also want to submit a certified copy of Ariel's plea agreement, as well as a copy of the state statute of conviction. Next slide, please. So we know that Ariel's conviction is not a CIMT. That said, they still need a 192 because they are inadmissible for entering without inspection and the permanent bar. So will you submit mitigating evidence about the assault conviction with the 192, even though Ariel is not actually inadmissible based on that conviction? Give folks about 15 seconds to respond. Okay, we'll go ahead and close the poll. So the vast majority of you have said yes, 71%. And I think that makes sense. It makes sense to submit that mitigating evidence because Ariel is inadmissible on these other grounds. And the waiver of inadmissibility that Ariel needs for EWI and the permanent bar in order to get their U visa, remember that waiver is discretionary. And as part of that discretionary decision, USCIS is going to consider this conviction, even though it's not a ground of inadmissibility. Basically, just because Ariel isn't inadmissible for this conviction doesn't mean that it won't be considered at all. Next slide, please. So you want to enter some mitigating evidence into the USCIS record to bolster Ariel's I-192. And how do you do that? Do you mention it just in your cover letter, or do you submit, other documents independent of your cover letter? We'll go ahead and close the poll. So it wouldn't be sufficient to just mention the mitigating information in your cover letter. And the reason for that is that the BIA has said that the statements of an attorney are not considered evidence. So actually, there was a mistake on this slide. If it wasn't just in your cover letter, it actually wouldn't be evidence. It would just be like information. If you want it to be evidence, you would have to feature it somewhere else in the filing other than just in your cover letter. Based on the fact pattern, what are some mitigating factors that come to mind that you would want to prove with some evidence in this filing? And you can go ahead and put that in the chat box. Seeing letters of support, proof of volunteering. Right, those are, yeah, really great ways to prove, the mitigating evidence. What about like the circumstances of this crime? Is there anything mitigating about the way in which Ariel got this conviction? Declaration about what happened, right? Donation receipts. So some, right, documentation of DV, exactly. If it was self-defense, show criminal record, statement showing rehabilitation. So, right, the connection between the conviction and the abuse, that is definitely a mitigating factor here. You'll see maybe not every case will be quite as helpful, but you'll see here that the abuse that Ariel was suffering at the time was strangulation. And there's some strong evidence on strangulation in particular as being an indicator of lethality in a DV relationship. So you could submit some evidence of that to show, just how severe the abuse Ariel was suffering was. And then that also helps mitigate, Ariel's response to that abuse with the slapping. We see that Ariel is non-binary and that there's some indication that there's mistreatment of non-binary folks at the county jail. That could potentially serve as a bit of an explanation about why Ariel pleaded guilty instead of fighting their case. We see that there were some language access issues with the police that prevented Ariel from being able to explain their side of the story. We also know that there is some medical research about differences in visibility of injuries based on folks' skin tone. We see here that, Ariel had darker skin, so the strangulation marks were not visible on their neck, as opposed to, Alejandro had the lighter skin, so the police were able to immediately see the red welt on Alejandro's face. So just you could submit like an explanation from Ariel, like some folks said, that would highlight some of these things, as well as maybe some medical and social science research to prove those factors. Okay, and now I will turn it over to Rebecca.
Thank you, Kelly. All right, next slide, please. We are going to shift gears. Completely different topic. We are going to talk about late breaking inadmissibility grounds. So next slide, please. So this topic covers what to do if you learn about an inadmissibility ground after you've already submitted your client's application. And mostly we are going to be talking about the context of a U visa, though much of it may be transferable to other contexts, especially a T visa as well. So what to do in these situations depends on the procedural posture, when the ground arises, compared to what applications have been submitted or decided. But before we get into the differences in what to do, just a reminder about why late-breaking inadmissibility grounds do need to be properly addressed. No matter the procedural posture, if a ground exists and goes unwaived, your client will not be able to lawfully obtain U status or T status. So for a U visa to lawfully obtain status, a person has to either be admissible or have any applicable inadmissibility grounds waived. If USCIS realizes a ground exists and it's unwaived, they usually will deny status entirely. But if USCIS doesn't know about the ground and approves your client despite them failing to waive it, that can constitute an error in adjudication. And if your client gets granted a U visa in error, there's a regulation at 8 CFR 214.14 I, B as in boy, that says that USCIS can revoke that grant at any time upon notice. And so it really puts at risk your client's status and their beneficiary statuses, and it may make it impossible for them to proceed to the next level of status, like adjustment or naturalization. So the only lawful and secure way for your client to progress is, if they were inadmissible, is to properly address that inadmissibility ground. And so what steps you need to take to do this depends on where your client is in the decision process, both when the inadmissibility ground comes to light and also when the inadmissibility ground actually arose, if those are not the same dates. So let's talk first about if you learn of a new or undisclosed inadmissibility before the application has been decided. In that case, the best thing to do is to disclose it and seek to waive it before the application gets adjudicated. To do this, you might be submitting another new I-192, or if your client previously filed an I-192, you may be able to write to the Service Center and request to amend that pending I-192. If you do the amendment, you'll be mailing the official amendment request with supporting documentation, referencing the receipt number of the pending 192 and 918, but also email a scan of it to the relevant hotline to guard against the Service Center misunderstanding your filing and rejecting it. When doing this, you will want to include an updated affidavit from the client where they explain the new inadmissibility, but also the reason it is being disclosed late, if that's the case, and the reasons it would, still be in the public interest or national interest to approve the waiver of this additional ground. So you want to be sure to include any additional positive discretionary evidence you have as well. All right, what if you learn of an unwaived inadmissibility after the form is adjudicated, yet the ground was triggered or existed before adjudication? So things are a little more complicated. It could arise in two scenarios. One is where your client actually disclosed the ground, but USCIS didn't waive it. And the other is where the ground was not timely disclosed. So for the first scenario, if you disclosed a ground, you may be able to just ask USCIS to be sure if it was waived or to waive that ground now. And if you aren't sure what was waived, you may be able to find this out by emailing the Service Center hotline or submitting a FOIA for the I-192 approval sheet and U1 checklist. You can see what USCIS's system says was waived. If you learn the ground really was unwaived, you can email the hotline again, demonstrate with an attachment that the ground should have been waived based on your initial submissions, and request that USCIS correct their omission and create a new 192 approval notice that adds this additional ground as waived. But if your client never disclosed the ground or the facts surrounding it, and now has an approval notice that doesn't include a waiver of that ground, you have to be more formal about getting it waived now. So just like in the prior scenario, your vehicle will be either a new 192 or a request to amend a previously filed 192. But the difference here is that the U has already been decided. And so this new I-192 or amendment has to be done in a way called nunc pro tunc, which means now for then. And it basically asks USCIS to create the legal fiction that the ground was waived before the U grant, so that the U grant can still be considered lawfully obtained. There's no real difference in process for an I-192 done nunc pro tunc, except you are going to want to clearly indicate in your cover that that is what you are seeking. And you are going to want to be conscious as you make your arguments and assess your evidence for sufficiency that what you are asking for is somewhat of an exceptional remedy, right? So where the client is affirmatively volunteering this need for a nunc pro tunc waiver, instead of filing it defensively, like where USCIS may have discovered the inadmissibility and threatened them with revocation, this can be a bit of an easier sell, but there is unfortunately a line of unpublished AAO cases that finds that defensive requests for waivers nunc pro tunc should be pretty rarely granted. Theory being it's an exceptional form of relief. Nunc pro tunc remedies generally exist to correct a problem wrought by the government or another circumstance outside your client's control, instead of something where it was just the client's failure to disclose something when they had full opportunity to do it. And so for this reason, you will want to include a new affidavit from your client, preferably additional sympathetic evidence as well, showing their regret, remorse, rehabilitation, surrounding not just the new undisclosed or the newly disclosed ground, but the failure to disclose it before and possible misrepresentation before. You want to, really lay on positive discretionary documents, take a look at the policy manual on discretion, document every single one of those factors that exists in your client's case, and just generally make it part of your practice to try to head this off at the beginning by really encouraging folks to that this is their one chance at the I-192 U visa phase to disclose and request everything to be waived. And so then finally, what if you find out about an inadmissibility ground after your client's U visa was approved, and that's because the ground arose after the U visa was approved? In this situation, If the ground didn't exist before the U adjudication, thankfully, there was nothing that should have been waived at that time. There will be no need for a nunc-pro-tunc 192 amendment, no 192 at all. The U status your client has was properly granted. And the only question is, what else is your client going to be applying for in the future? And how will this new ground affect that application? So for a U non-immigrant, the next step is usually going to be U adjustment of status under 245M. And that particular form of adjustment does not require admissibility. You definitely don't want to conceal the new ground if there's a question about it on the 485, which there is for most grounds. But this ground is actually going to be taken into consideration only as part of the discretionary analysis, whether it's in the public interest to grant this application for adjustment. So no 192 waiver needed, no 601 waiver needed. Just document well any mitigating factors and have your client show remorse, rehabilitation, respect for the law in this new application. Of course, if your client is seeking some other status, like maybe a T adjustment or naturalization, the elements are different. And so that inadmissibility ground, it may affect the new application differently. They might need a waiver, or they might assess the risks and just think they don't want to even bother applying for this new status and being found ineligible. It totally depends what the ground is and what benefit they're seeking. So let's take a few examples, starting with Sandra. So next slide, please. So Sandra received a U visa in 2019 based on domestic violence. She comes to your office for a U-based adjustment. She discloses she entered the US in 2014 with her 3-year-old child without permission, and the smuggling ground of inadmissibility was not waived. If you could please launch poll 10. So what would you do? Would you file a nunc-pro-tunc request to waive the smuggling ground, disclose it in the adjustment application, and ask for favorable exercise of discretion, or both? Or would you do something else? If you choose something else, if you could please share that in the chat. Okay, a couple more seconds. And let's end that poll. And it looks like we've got 53% would do both, 26% would just file a nunc-pro-tunc and, waiver request, and 19% would disclose the adjustment application. And one person looks like wrote, if not disclosed due to attorney error, do you recommend a declaration? I'm not sure if that's actually from this question. But yeah, so it looks like, thank you. What we have in this situation is a smuggling ground of inadmissibility, should have been waived at the U visa application phase and wasn't. So now what Sandra got was an application that was approved erroneously. And if this goes unaddressed, she will be at risk of having her U status revoked, right? If that's what really happened. Now the facts do say she's feeling ready to file for U adjustment of status, which doesn't require admissibility, but you shouldn't let that fool you because her inadmissibility ground arose before the U application, which did require admissibility. And so the correct answer here would be, at least for now, first, we are filing a nunc-pro-tunc request to request to waive this, nunc-pro-tunc waiver to request to waive the smuggling ground as though it had been waived at the U application phase. All right, let's go on to the next slide, please. We've got Fatima. Fatima received a U visa in 2020 based on stalking. You represent her on her U-based adjustment application. And when reviewing the 485 questions, Fatima tells you she gave her sister Farah money in 2022 to come to the US, and Fatima knew that Farah did not have authorization to enter the US. Last July, Farah did enter the US through the Canadian border without inspection, and she used Fatima's money to pay a guide to help her cross. Would you please launch poll 11? What would you do? Would you file an I-192 and request a waiver that way, file a 601 and request a waiver, disclose on the adjustment application and ask for favorable exercise of discretion, or something else. Okay, a couple more seconds. All right, let's end the poll. And this looks pretty evenly split between the first and the third answer. We've got 41% saying file the 192 to request a waiver. And then close second, 39% saying to just disclose on the adjustment application. And then about 20% saying to file a 601. Right. So here, unlike with Sandra, Fatima did not become inadmissible on this ground until after her U visa was approved. And so the question is, what is she applying for now? And how does that ground affect that application, right? Nothing was wrong with her U status. So here she's doing a U adjustment application. We talked about how those applications under INA 245M don't actually require admissibility. And so looking at these answers, we know that actually A wouldn't be necessary because 192 waiver, it's a non-immigrant waiver for issues that existed at that U non-immigrant application phase. Here it didn't exist then. She's at the adjustment phase. She doesn't need anything related to her non-immigrant status to be waived or corrected, so it wouldn't do A. B also would not be correct here, although an I-601 is an immigrant visa and admissibility waiver, and it does accompany some adjustment of status applications. It exists to waive inadmissibilities, and since U adjustment doesn't require people to waive inadmissibilities, it's not necessary here. And so that means that it's C that would be the best option for Fatima. She will just have to be forthcoming on this adjustment application, explain what she did, show regret, remorse, rehabilitation, the reason she did it, prove that it nonetheless would advance family unity, humanitarian interests, and otherwise be in the public interest to grant her adjustment of status in the exercise of discretion. All right, and that is it for inadmissibility grounds. I'll turn it over to my colleague, Leah.
Right, so we'll be going and talking about health-related grounds of inadmissibility. If we can go forward one slide and then the next slide. So we'll start with a hypo. We're talking about Luca here. So he's the U3 child of a DV survivor, and he applied for adjustment of status last year. You just got annoyed for his AOS because the civil surgeon failed to give him a required vaccine. That vaccine has 2 doses, and he will not have time to receive both doses before the NOID deadline, even with the COVID extension. What can you do? If you want to put some ideas in the chat, what would you do here? If someone would file a 539 to extend the U. Ask for an extension in their exercise of discretion, or a 601 question mark there. Get them the first dose and then get a new medical exam after the second dose. Proof that he has something scheduled. All right. So these are all great ideas. Thank you. And feel free to put more in the chat. So some things to consider. First off, we know he says a U3 child. We don't know his age. So that's one thing to consider too. And another big question here is, what is the vaccine we're actually talking about here? Because different rules apply. So we'll just go to the next slide, and we have a lot to cover here. So I'll start with the vaccination for Luca. So vaccinations are a requirement for inadmissibility grounds under INA 212A1. there is a different rule of, the vaccinations required and COVID-19. So starting first with all the other vaccinations, USCIS recognizes that some vaccine schedules can take months or years to complete. And so it's not going to be possible to complete a full series before adjustment. And so that's not required. Instead, they would have to receive at least one dose of each age-appropriate vaccine for which they're not currently up to date. So, as some of you mentioned, at least get that first dose. That could be enough, as long as he gets that first dose to show that he has started the series and he can complete it, and that wouldn't stop his adjustment. COVID-19 vaccination, however, does have a different requirement, and that USCIS says must be completed before the civil surgeon can complete the medical exam. So if we're talking about the COVID-19 vaccination, if there's not a single series vaccination still available, and I'll admit to not knowing if that's still the case in most areas, but it is a 2-dose series that he can't complete before that time frame, then we might be looking at other waivers, or as some of you mentioned, at least discretionarily asking for more time, which USCIS might want to grant. So what are these waivers? And this slide shows the waivers are at INA 212G2. There are two different categories of waivers for vaccinations. One are blanket waivers, and then there are individual waivers. So blanket waivers include that a vaccination is not age appropriate. It will say for COVID vaccinations, the lower age limit for that requirement is now 6 months of age. And so it's very unlikely that we're talking about that here, but just flagging that. Insufficient time interval between doses is what we discussed, where that could be a reason for most vaccinations, but would not apply to the COVID-19 vaccination if that's the vaccination we're talking about here. Other blanket waivers include if someone is pregnant or immunocompromised and can't get that vaccination, and that would be documented in the medical exam, and whether there's a nationwide vaccination shortage or that vaccine is not routinely available. If there's a shortage, that would be something CDC would have to assess. And since we're talking medical exam here, an adjustment, they're in the US, and so likely those won't be the reasons for at least the COVID-19 vaccination. Individual waivers are a separate category, and that would require a waiver application, and that would be based on religious or moral convictions. So here, the individual would have to show, and if this is something that would apply to Luca, you would have to show that he's opposed to all vaccinations in any form, that objection is based on religious beliefs or moral convictions, and that religious belief or moral conviction is sincere. So that means that it's truly held and that it's applied consistently in the applicant's life. So just because someone has previously received vaccines does not automatically mean they do not have this sincere religious belief or moral conviction. They could have converted religion or have some other life event, but they will have to show in their waiver request that this is a sincerely held belief or conviction, and therefore they are opposed to all vaccines. And it's really important to say that, because if they're only opposed to the COVID vaccine, but are okay with all others, it's very likely that this waiver request would fail. For the other categories of health-related grounds, just briefly speaking, physical or mental disorders associated with harmful behaviors. So the statute does talk about past and present physical or mental disorders, but you need to have both elements. So not just a diagnosed physical or mental disorder, but it also has to have that associated harmful behavior, which means that it does pose, has posed, or is likely to pose a threat to property, safety, or welfare of the non-citizen or others. If we're talking about a past disorder with associated harmful behavior, that behavior has to be likely to reoccur or lead to other harmful behaviors. The waiver is also at 212G sub 3. And this is a waiver USCIS can only grant after consulting with the CDC about the specific case. So CDC would review to determine if there's a Class A condition that leads to inadmissibility, and other details, for example, to know whether that individual has identified a physician for treatment. And USCIS would then review what the CDC says and independently determine whether to grant this waiver. Drug abuser addict grounds. So that's use of controlled substance and meeting the DSM criteria for substance use disorder for using that controlled substance. I want to flag that this does include marijuana since it is still a federally scheduled controlled substance, despite what state law and public opinion and just logic would say that it should not be treated the same way as other controlled substances. But this also means that this does not include alcohol or tobacco or anything else that is not listed under the federally controlled substance schedules. Another thing to flag, there is no waiver available for this ground if it is triggered. However, the INA does use the present tense to say that someone is a drug abuser or addict. And so if someone is in remission, they would not be inadmissible under this ground. However, remission is defined as 12 months without use of the controlled substance and not meeting any of the other requirements for a substance abuse disorder other than craving. And they would need a new medical assessment from the civil surgeon to prove that they are in remission. And finally, communicable diseases of public health significance. So there are several communicable diseases defined that include like leprosy, infectious syphilis, active TB, and it also includes COVID-19. There is a waiver at 212G sub 1. Someone must have a qualifying relative or be a VAWA self-petitioner for that waiver, but they do not need to show hardship to that qualifying relative. Again, USCIS would consult with the CDC and determine whether to grant the waiver, and that could be subject to terms and conditions as well. Next slide, please. So we're going to shift gears into different inadmissibility grounds. So here we're going to focus specifically on VAWA and the 3 and 10-year bars. Next slide, please. So 212A9B is where we find the language for what's known as the 3 and 10-year bars. So the 3-year bar is unlawful presence for more than 180 days, but less than a year, and then a departure. And the 10-year bar is unlawful presence for more than a year, or at least a year or more, and then a departure. And what we see on the slide on the left here is the statutory exception for VAWA self-petitioners for the 3 or 10-year bars. And if you look at the language, it's actually pretty narrow. Here they say that you're substituting violation of a non-immigrant visa for the clause unlawful entry into the United States. So essentially it says the exception applies if there was a violation of their non-immigrant visa. And that's narrow because we know a lot of self-petitioners do not enter on a visa or they entered illegally through the border. And so violation of, or they did violate a status, but it's not actually tied to the abuse. So on the right, we actually have USCIS policy, which is actually way more generous than the statute requires. And here they say VAWA self-petitioners just have to show a substantial connection, substantial connection between the abuse suffered, the unlawful presence, and their departure from the US. So again, this is much broader. It doesn't just narrow it to the violation of a non-immigrant visa. What is something to flag, though, is this and language, that the substantial connection is not just between the abuse and the accrual of unlawful presence, but also their departure. Different field offices interpret this and a little bit differently, and so it's really good to check with local practitioners to see how this exception is handled locally. But that and does make it a bit more restrictive because a lot of self-petitioners can show, for example, connection between the abuse and their departure, but they might not be able to show that connection between the abuse and the unlawful presence that they accumulated. What's important to flag too is someone does meet this exception, they are not inadmissible under the 3 or 10-year bar, so they don't need to request any waiver. This would be an exception, not a waiver application, so they wouldn't need a 601, but they would have to show the substantial connection to the abuse and their triggering of this bar. Next slide, please. What do we do if someone doesn't meet this exception and there's no connection to the abuse? So in June of last year, USCIS issued a policy update regarding the 212A9B grounds of inadmissibility. So essentially, the TLDR of this is that 3 and 10-year bars do run in the US. But what it does say is that that bar period begins once that individual departs or is removed and runs without interruption from that date. They would not then be inadmissible under 212A9B unless they're seeking admission within that bar period, whether it be the 3 or 10-year bar that they triggered. And most essentially is their location during their bar period, the bar period, and how they return to the US are irrelevant for the purposes of the A9B ground of inadmissibility. This was also updated in the policy manual, and so this is something that is in effect currently. Better news is the BIA recently also issued a decision that confirms this for BIA purposes and in removal, that the 3 and 10-year bars run in the US. And again, this is all based on the plain language of the statute, because it doesn't say that someone has to remain outside the US for the entire time of the bar period to have that bar period run. One important thing to mention is that we are only talking about the 3 and 10-year bars here, not the A9C permanent bar, which we'll discuss in a little bit. And so that's important to flag. That plain language difference is A9B, 3 and 10-year bars don't talk about location, which is very distinct. So that's why for these 3 and 10-year bar periods can run continuously, regardless of where the individual is. Next slide, please. And we're going to see this in action. So we have May here, who entered the US on a visitor visa with authorized status until December 1st, 2010. But she remained until June 2012. She returned on the same visa in June 2013. After that return, she met and married her husband, who became abusive to her during her pregnancy with their first child. She now wants to file a VAWA self-petition and adjustment of status application. So we have a poll on the next slide. Is May inadmissible under 212A9B? Yes or no? Give it about another 10 seconds. All right, another few seconds and then we'll close the poll. All right, let's close out the poll. And we have 62% say yes, she is inadmissible, and 38% say no. So let's break this down. If we can go back a slide, just so we can see the facts again. So we have that she was authorized to stay until December 2010, and she left in June 2012. So even without knowing the exact date, we know that even if it was June 1st, and I do recommend the time and date calculator online for this. She has over about a year and a half of unlawful presence that she accrued, and then she departed. So if we look at the language of A9B, she had over 1 year of unlawful presence and then left, and would have triggered the 10-year bar in June 2012 when she left. Per that new policy, it doesn't matter how she re-entered, that bar started running in June 2012. So we add 10 years to that, brings us to June 2022, and we are past that. So she is no longer inadmissible under this ground because the bar has run. So she doesn't need to file a 601. She doesn't need to show the VAWA exception. She's just not inadmissible for the 10-year bar. So this is helpful for those where they can't show that connection to the abuse, for VAWA self-petitioners who can't show that connection and would have been inadmissible under this ground, but where the ground has also run, and so they are no longer inadmissible under their ground. It's also important to keep in mind, if she were eligible for another form of relief, say she was applying for a T or U visa, this would still say the bar has run, and so she wouldn't be inadmissible and need to get that waived for the purposes of the U or T status either. Next slide, please. Actually, and another one after that. So we'll go to poll 13. And so we have some more details here. May is in removal proceedings. Her attorney asked OPLA to agree to termination after her self-petition was approved. OPLA refused because she has a felony arrest on her record. Is she eligible to adjust before the immigration judge? And we'll leave this poll open for about 15 or so more seconds. And we'll close it out. Thank you. So 69% of y'all said yes, and 31% said no. So let's look at this. The issue of whether she's eligible to adjust before the judge, we mentioned the bar period has run. We also mentioned there's a BIA case. And so that case now says the BIA has ruled on this issue of the 3 or 10-year bars running regardless of where the individual is and running continuously. So adjustment is a possibility in court now. Prior, it was only guaranteed as a possibility before USCIS, but thankfully we have this decision from BIA. And so adjustment before the judge should be possible. I do want to flag, and maybe some of your no's were based on this felony arrest on her record, that can be a negative discretionary factor, and certainly different things to explore here, but might not necessarily be fatal to her eligibility. But in terms of whether the 3 or 10-year bar prevent her from being adjustable, that is not the case. So thanks y'all for your participation, and now I'll pass it back to Kelly.
Thanks, Leah. Can we go to the next slide, please? Thank you. So just like for some grounding, the reason we're talking about inadmissibility for VAWA self-petitioners is because, remember, for adjustment of status based on VAWA, it's under 245A, where you have to assess each individual ground of inadmissibility to see whether a waiver is available and whether your client meets the requirements for that particular waiver. And that way it's very different from U non-immigrant status, where there's, pretty much a blanket waiver that applies to almost all grounds of inadmissibility simply because someone's applying for a U visa. Since permanent bar inadmissibility does come up for VAWA self-petitioners, it's important to have an understanding of whether your client is eligible for the waiver of the permanent bar that is available to VAWA self-petitioners. We have received questions through technical assistance on whether one of the events that triggers the permanent bar, so for example, a departure from the United States, that was connected to abuse by a different abuser, so that is the non-VAWA abuser, qualifies the client for the VAWA-based waiver of the permanent bar. And that's why I've chosen to cover that particular aspect of the analysis in this portion of the webinar. Next slide, please. And to ground us in this discussion, here is the statute that allows for a waiver of the permanent bar for VAWA self-petitioners. It says that the Secretary of Homeland Security may waive the application of Clause 1 in the case of a non-citizen who is a VAWA self-petitioner if there is a connection between the non-citizen's battering or subjection to extreme cruelty and the non-citizen's removal, departure from the U.S., reentry or reentries into the U.S., or attempted reentry into the U.S. Now, this is different than what Leah was talking about earlier, since it is a waiver and not an exception. That means that the client would have to affirmatively request that waiver from USCIS on Form I-601. And the reason that the client would submit a 601 and not an I-192 is because the VAWA waiver of the permanent bar is an immigrant waiver, and the 192 is a non-immigrant waiver. Next slide, please. So I have here on the slide a comparison of the statute and USCIS's position, which is expressed in the form instructions for the 601. As you can see, USCIS's position is very different than the statute. USCIS requires that at least one of the events that triggered the permanent bar was connected not only to battery or extreme cruelty, but battery or extreme cruelty by the VAWA abuser. But you can see from the statute, there's no specification of who has to actually commit the battery or extreme cruelty that is connected to that triggering event. And I have here that USCIS's position is a regulation because it's in the form instructions, and the form instructions are part of the regulations. Next slide, please. So we have Zola. She was previously married to Ashley, an abusive US citizen. Zola has an approved VAWA self-petition, and she wants to adjust status based on VAWA. Zola entered the United States with a work visa in 2008. She accrued 2 years of unlawful presence, and then she returned to Zimbabwe. In Zimbabwe, she began dating Peter, an abusive police officer. Peter threatened to kill Zola. Fearing Peter and unsure of her safety in a neighboring country, Zola flew to Colombia and then journeyed to the United States on foot. Zola entered the United States without inspection after accruing 2 years of unlawful presence, and she has remained here since that time. Zola met Ashley after her entry without inspection, so there was no connection between Ashley's abuse and any of the events that made Zola inadmissible under 212A9C. Next slide, please. So knowing what we know about what the statute says, about what the regulations say, and about the fact that there was some abuse that was connected to that triggering event, but it was not the VAWA abuse, do we think that Zola is eligible for that VAWA-based waiver of the permanent bar? Give folks about 15 more seconds to respond. Okay, we can go ahead and close the poll. Thank you. So we have, it's pretty split here. We have 42% saying no, a close second. We have 36% saying maybe, and 23% saying yes. Okay, so we'll go to the next slide. So I think the answer is it depends on what we're looking at in terms of our source of law. If we're looking at just the regulations, then I would agree with the folks who said no, because it's pretty clear here that Ashley's abuse does not have any connection with Zola's entry to the US without inspection. It was Peter's abuse that caused that entry. That said, if we're looking at the statute, Zola might have some better arguments. Remember, the statute doesn't require that the VAWA abuser was the one who committed that battery or extreme cruelty. The Supreme Court has commented on similar scenarios, and they've said, in the case of Romag Fasteners versus Fossil, nor does this court usually read into statutes words that aren't there. And then in Lomax versus Ortiz Marquez, they said, this court may not narrow a provision's reach by inserting words that Congress chose to omit. Yet what is USCIS doing here? By saying that the battery or extreme cruelty that caused that triggering event must have been committed by the VAWA abuser, USCIS is reading into the statute words that aren't there, first of all. And second of all, they're actually narrowing the reach of this waiver provision because they're restricting the amount of people who it's applied to by adding words that, as we'll talk about, Congress chose to omit from that provision of the INA. And we can infer that this is an intentional omission. And that's because when Congress wanted the battery or extreme cruelty in an immigration context to have been committed by a specific person in other parts of the INA, they very clearly said who had to commit that battery or extreme cruelty. For example, in the VAWA self-petition statute, it's very clear who has to commit it. In the VAWA cancellation statute, same thing, very clear. And then also in the battered spouse waiver provisions, the use of that phrase, battered or subjected to extreme cruelty, is accompanied by a very specific statement on who has to commit it. And this reflects the holding in INS versus Cardoza Fonseca, which is a Supreme Court case in your materials, which says that when Congress includes particular language in one section of a statute, but omits it in another section of that same act, we're going to presume that Congress acted intentionally in the inclusion or exclusion of that language. And we know that some parts of the INA that contain this same exact phrase, subjection to battery or extreme cruelty, are accompanied by a mention of who committed that battery or extreme cruelty. So given that some parts of the INA say who committed it, and 212A9C does not, we can infer that Congress acted intentionally in saying that, no, there does not have to be a specific person who committed this battery or extreme cruelty as long as, it occurred and it had a connection to that triggering event. And because we can infer that Congress chose to omit this, that proposition that a provision cannot be narrowed by inserting words Congress chose to omit, that goes to show that USCIS's interpretation is wrong, because that's exactly what they're doing. They're narrowing who can qualify for this VAWA-based waiver by inserting a provision that, tools of statutory construction show us Congress intended not to be in that portion of the statute. And that brings me to a second and related argument for why USCIS's position is wrong, and that is the canon against surplusage. And that is expressed by a Supreme Court case that's here on your slide, where they say that we construe statutes where possible so as to avoid rendering superfluous any parts thereof. So to avoid rendering it, redundant or not unnecessary. And for USCIS's interpretation to work, they'd have to either add words to the statute, which we already know that generally they cannot do, or they have to argue that somehow this term, battering or subjection to extreme cruelty, actually means battery or extreme cruelty by the qualifying abuser. But that interpretation doesn't make any sense given the other places in the INA where that phrasing appears. And those places, like we've talked about before, are in INA 204, the VAWA self-petition statute, in 216, the battered spouse waiver statute, and in 240A, which is the VAWA cancellation statute. And the commonality there is that this phrase, battered or subjected to extreme cruelty, does not appear alone. It appears with a description of the person who had to have committed that battery or extreme cruelty, which is the qualifying abuser. And if battering or subjection to extreme cruelty means what USCIS seems to think it means, that it really means, battery or extreme cruelty by the VAWA abuser, then the inclusion of who has to commit the battery or extreme cruelty in all of those other places of the INA, in INA 204, in 216, and in 240A, that would be superfluous because it would be implied in, the meaning of that phrase, battery or extreme cruelty. And we know that, courts, when they're interpreting statutes, they're supposed to avoid rendering any part of the statute superfluous. But if USCIS is saying that's what this means, that battery or extreme cruelty means, implied in that meaning is that the qualifying abuser committed it, then any other mention of who committed it in any other part of the INA, it would be superfluous. And that's another reason to find that, to argue that, USCIS's position is wrong here. Unfortunately, the AAO and USCIS will probably reject these arguments, since they'll say that they have to follow the regulations as they're expressed in the form instructions. But that doesn't mean that folks shouldn't be making these arguments. Potentially, if USCIS starts to see these arguments more often and see how common these situations are, and that, their unduly narrow interpretation of this waiver provision really is restricting, the safety, stability, permanency that is supposed to result from the ability to adjust based on a VAWA self-petition, they potentially could change their position on this. If not, this issue will probably have to be resolved through litigation, since it's a question of how to interpret the INA. In this type of situation, where you're trying to argue that non-VAWA abuse should qualify the client for the waiver, you might be more successful in front of the IJ, because I'm not aware of a uniform EOIR interpretation that is similar to the interpretation in the 601 instructions. But one wrinkle in immigration court is that non-citizens who are subject to the permanent bar have necessarily entered without inspection. And that matters because entry without inspection is a ground of inadmissibility. And remember that VAWA self-petitioners have to show that either they're admissible or eligible for a waiver, and you have to look at each ground to see if one is available. Now, USCIS's policy position is that VAWA self-petitioners don't have to request a waiver for entry without inspection, that they're essentially exempt from that ground. But USCIS is a different agency than EOIR, and EOIR does not have to follow that interpretation. There is a waiver of the entry without inspection ground for VAWA self-petitioners, but it does require a substantial connection between the entry without inspection and abuse of the non-citizen or their child by the non-citizen's spouse, parent, or a member of the spouse or parent's household when the abuser consented or acquiesced to that abuse. So it's a lot narrower than, USCIS's interpretation, which is just essentially we have a blanket exemption. So that's something to keep in mind if you are making these arguments in front of the immigration judge. If Sola was trying to adjust before the IJ, she could run into problems if the IJ was not willing to adopt USCIS's policy about iwi inadmissibility. And that is because the abuser who caused her to enter without inspection was not her spouse, parent, or a person in the spouse or parent's household. So she wouldn't be eligible for that waiver for VAWA self-petitioners. While IJs are not bound by USCIS's policy about entry without inspection for self-petitioners, the trial attorney would not be able to argue that the client is required to seek a waiver since they are bound by USCIS policy, since they're part of the same umbrella agency as USCIS. If you're before an IJ, one of these cases, you can make your arguments for adjustment in court and then have VAWA cancellation as a backup, assuming that the client meets the requirements for VAWA cancellation. We don't have all the facts in this particular hypothetical. Most importantly, whether Zola has a criminal history that makes her inadmissible or stops the clock on her continuous physical presence. But it seems like she might be eligible for VAWA cancellation, assuming she doesn't have those issues. Since she was married to Ashley, a US citizen, she's lived here for more than 6 years, and she probably has some pretty good extreme hardship evidence, given the fact that, Peter was the abuser and was in a position of authority in home country. And are there any other arguments that folks would like to share that have worked for them in their cases when their VAWA client was trying to adjust status and was inadmissible for the permanent bar based on abuse that was perpetrated by a different abuser? Okay, thank you. So I will say, like I've said, that I've seen most of the time that USCIS will apply this position that it does have to be connected to abuse by the qualifying abuser, but there are arguments against that based, on strict interpretation of the statute, which, that's what courts do. So it's helpful to be making those arguments because it goes to show USCIS, that this is a problem and that they should consider changing their position. Next slide, please. Okay, I'll hand it over to Leah.
Right, next slide. We've got our last poll, so get ready. Which of these have you experienced in your survivor-based cases? A file transferred to the wrong location, an AR11 or G28 being rejected, saying you can do that online, a supplemental filing, or a response to a NOID or RFE that was rejected, also saying you can do that online, delayed receipt notices, or the fun option of all of these. And if you want to put more details in the chat, absolutely feel free to. I'll leave this open for another 10 seconds or so. And if it's any comfort, we've heard of these issues just all around. So it's not you, it's USCIS. All right, we'll close the poll. Thank you. And so, okay, the majority of you are reporting delayed receipt notices. 36% of you are lucky enough to have all of these issues come up in your cases. And the rejections and file transfers to the wrong location coming up too. So absolutely feel free to give us more details or schedule a TA in cases where that might be necessary. But this is something we have noticed. And so to give some more information, we'll go to the next slide on best practices of handling issues with USCIS. So the big one, which many of you already know, is to document everything. So that means keeping copies of everything you file, even if it's just an address change or supplemental filing, and also keeping copies of all the tracking information. So not just what the tracking information is for which case and what you were filing, and recommend keeping a copy of delivery confirmation. Some of you might use different programs that allow you to keep those records a bit longer. But for example, like the Postal Service only keeps certain records for about 120 days. Other services may have records for a year or two. But given how long these things can be problems, you might not be able to go back and find that confirmation, which could be important, especially when USCIS is delayed in actually receipting in something or puts the wrong date on that receipt and it affects eligibility. Also keep a copy of any communications with USCIS, and that includes when you contact the hotline. So we do recommend contacting the hotline when there is this issue that arises, to give them the opportunity to address the issue before escalation. And we do have some materials about that, or we have information about that in the materials. We do recommend that you attach your G28 to the email, even though it is on file, just makes it much easier for that officer reviewing the email. And having a pleasant enough tone, even though sometimes it feels like a frustrating step that won't actually get anywhere or won't get you a response that's actually responsive to the issue. Most important thing is to at least have this communication that you attempted to give USCIS the chance to correct any issue or amend some problem prior to escalation. And this will be important for any escalation, whether that be with us or, as on this slide, the ombudsman or a congressional rep. So the ombudsman, the materials do have more information on this. They can help with a lot of different case issues, including non-receipt of notices or decisions, improper rejections due to clear errors of fact or misapplication of law by CIS, or age out cases, lost files, a bunch of things. But they'll also want to know what steps you've taken with USCIS before escalating with them. With a congressional rep, we also have a practice pointer on looping in a congressional liaison. And this can be helpful where a case needs to be expedited, particularly where there's age out or other urgent concerns, where there's just no response whatsoever, despite all the efforts to know what's going on in a case. But can generally be used for a lot of different issues with USCIS. And it can be helpful where somebody lives, where there's a congressional rep that is willing to go to bat for them, because they were required to answer in a way that sometimes is helpful. And so these are different ways that can escalate, but the most important thing is not only to have your record, but also communication with USCIS that you tried with them first. Next slide, please. When can we help? So you have to, again, try USCIS channels first. Again, this generally involves contacting USCIS directly through the hotline, sometimes through mailing, depending on these specific issues, to try to resolve that issue first or get more information or what have you before the escalation. Do want to flag that while we're talking about trying USCIS channels, that does not mean that you necessarily need to do an ombudsman escalation or congressional rep before getting us involved. Sometimes it's worth using all these avenues at the same time. I know in instances of age outs and consular processing cases, sometimes that all hands on deck situation is really necessary. But do keep in mind that the congressional rep and or the ombudsman might have their own requirements. For example, the ombudsman site does have language to say that if you have your congressional rep doing an inquiry and it's been less than 30 calendar days, they won't help or be able to help until after that time has passed. So just as you figure out your order of operations there. It's really important to have a clear ask. So what is actually the request? What is the issue? There's a difference between saying, hey, this case is 2 years out of processing time. So here's all the efforts we made. We just want a decision, and hey, grant this case. But it's really good to know what actually the issue is, what steps have been taken, because sometimes with those steps taken, other issues arise, including non-responsiveness from the hotline. So it's really important to have all that documented. To get our help, so just sign in through the TA system to schedule a TA appointment with us. That'll be where you speak with one of us to figure out what's going on in the case, what's been done so far, whether additional steps might be possible or needed before we get involved, and also discussing what an intervention would look like. What happens after we intervene? Well, that's the fun part, is we don't always know. USCIS will not respond to us directly on these requests because they are protected confidentiality wise, and we are not the attorneys of record. So we usually hear back when you hear back and let us know. So if there is movement on the case, you will typically, as the attorney of record, receive that notice or that information or that update to know if the case is moving along or whatever the remedy we were requesting was. So at that, we have about 5 minutes left for questions. I did also want to flag that if you want more information about our TA interventions and different things available, I'll put a link in the chat to register for our orientation on the 29th of this month. And that'll give you more information about what we can do to help in cases and just our services generally. And with that, I will pass it back.
Thanks so much, Leah. We have a few questions. We have one about if VAWA petitioners with a pending I-360 and I-485 leaves the United States before advanced parole is approved, how can this person return? I realize the adjustment is abandoned, but how to bring the petitioner back to the United States? So I think that would depend on, first of all, if the 360 is approved or not, eventually while they're outside of the United States, and also whether they incurred any inadmissibility by departing the United States. So, you know, they're during the time they were in the US, where if they were accruing unlawful presence and then departed, they would have to worry about a 3 and 10 year bar problem, 3 or 10 year bar problem. And for that waiver, you know, they would have to show, it might be difficult for them to argue for that USCIS more generous interpretation, because they'd be, you know, adjusting before the Department of State, or they would have to request a waiver base, and then for that they would have to have a qualifying relative. So I would say it might be more difficult to bring them back if they accrued a ground of inadmissibility by leaving the United States. But if it's a case where there is no inadmissibility problem, they could come back to the United States on an immigrant visa based on their approved I-360 through consular processing, because while there is a requirement generally that the abuse occurred in the United States, the self-petitioner doesn't have to be in the United States in order for that self-petition to be approved. And it is intended to be a path to either an immigrant visa or adjustment of status. We have a question. What should we do if a client has pending charges that might make them inadmissible if they were to plea to the charges? So I would say in terms of inadmissibility, I think it makes sense to wait to say that the client is inadmissible until you're actually sure that they've, you know, actually pleaded guilty to those charges, since there to be a valid admission for the purposes of inadmissibility, there's a very, you know, specific test that has to be met. The person has to, you know, have been read all the elements of the statute in terms they understand, and then they make a free and voluntary admission to it, which is probably unlikely. So generally, to be inadmissible, they do have to have that conviction. So in terms of the 192, amending it or anything like that, I would say to wait. In terms of whether to, you know, amend the form that asks if the client has ever been arrested, that's really up to the practitioner. There's differences of opinion on that, of whether folks should affirmatively amend the form or wait for a request for evidence. So I'd say that's matter for your judgment, but definitely in terms of the inadmissibility, I would wait until you have more information about what the conviction is.
I do see a question about a passport that was valid. I believe it's about a passport expired while a U was pending on appeal. It was valid at the time of the appeal, but at the time of reopening approval, the passport had expired and she didn't otherwise need an I-192. So I was trying to find, I can't find where USCIS policy generally is that where the passport was valid at the time of filing, they, like if there was a valid passport, they're not finding that inadmissibility ground. Again, we generally recommend a 182 where that applies, but the policy currently is USCIS hasn't been holding that inadmissibility ground against anyone. So I don't know that that would be an issue for adjustment if she's now eligible for adjustment, but if people have had different experiences, feel free to share.
I think we are at time. So thank you so much, everyone, for your really great participation in today's webinar. We really appreciate it. And thank you to Leah and Rebecca. And please remember to fill out the evaluation. It'll pop up at the end of the webinar on your screen. And we really do read your comments, and they help us plan future training. So we would appreciate it if you could fill that out. And we hope to see some of you soon for our conference, March 22nd to 23rd, and then at the orientation on March 29th. Have a great day, everyone.